number 18, the people of the state of New York versus Jeffrey Bush, and we'll give our colleagues one moment to collect themselves before we begin. You may remain where you are. Thank you. Okay. Good afternoon, counsel.
Good afternoon, Your Honor. 2 minutes for rebuttal, please.
You may.
Thank you. May it please the court, Ying Ying Ma on behalf of the appellant Jeffrey Bush. When a sentencing court upends the promised plea bargain on the day of sentencing with a completely new type of sentence which was never mentioned before the plea, no burden of preservation is placed on the accused because there was not sufficient notice of this new sentence.
Ms. Ma, wasn't this the judge asking? It was more an inquiry of the sentence, is this a CD, rather than an imposition of the sentence. So couldn't at that point somebody said, no, that's not what it is, Judge. I don't understand why under these circumstances the judge asking what the sentence was wouldn't allow for the defense a meaningful opportunity to object.
Well, the reason for that is Mr. Bush, as a lay person, he has no idea what the two letters CD meant. Maybe his lawyer understood that to be the promise, but that was not the promise that was put on the record at the plea. That's clear from the plea minutes. Mr. Bush had no idea that he was going to be sentenced to a conditional discharge. And when the court just
But
used...
the record is also clear that there was a negotiation. This plea went from a felony to a misdemeanor. His attorney negotiated out the possibility of probation, and it was clear that community service would be a part of it. The question is, how does the court pronounce sentence to accommodate the requirement of the community service?
Well, I understand Your Honor saying that a community service sentence can only be imposed along with a conditional discharge, but that doesn't mean the court is not still obligated to put that on the record. Mr. Bush does not know that. I don't think many lawyers even know that, you cannot impose a community service sentence without a conditional discharge.
So it's not enough that he knew the most he faced if he didn't complete the community service was a year in jail. The court needed to specifically tell him the mechanism that was going to be utilized in order to impose the sentence of community service. Is that what you're saying?
Yes, I think when the court tells him at the plea, don't get arrested, otherwise you'll face a year in jail, it's unclear that that is for, it's completely not stated that that's for a year after he completes the sentence. It could very well mean only in the period between the plea and the sentence, which is a very traditional condition of a plea, to show up to court, to not get rearrested, and to complete any conditions.
So could I, I'm sorry.
Go ahead.
Could I, I've never practiced in New York criminal court, so you need to help me a little bit here. What do I make out of the form, the conditional discharge form that's at page 820? So when I read the record, it's at least possible, but I have no idea if this is right or not, that what normally happens is you take a plea, there's a date for sentencing, that's the return date for sentencing, and that at that point, this form is filled out with the conditions for the conditional discharge in it, and then you meet whatever those conditions are thereafter. But that something anomalous happened here, which was that Mr. Bush completed all his community service before this form was ever filled out. But he did sign the form, and it does say a year, and it's a year from that date.
Yes, that is, well, the normal procedure is normally when somebody gets community service, it's on a misdemeanor plea, and so plea and sentence are imposed at the same time, and then the form is given to the person. It's unusual that on an indicted felony, there would be a plea down to a community service sentence, so that's why this case has somewhat unusual facts. And it's true that Mr. Bush did not object, but this court has, in People v. Turner, which was a very similar case, where the defendant there was not told about post-release supervision at her plea, and then at her sentence, the court announces it for the very first time. Ms. Turner as well, she did not object, but not only that, she also told the court specifically that she had spoken to her lawyer about post-release supervision and that she was still ready to proceed with sentencing. And the court still found that preservation was not required in that case because she didn't have sufficient notice. She wasn't given the knowledge that she would face any period of post-release supervision. And the court specifically takes the time in its decision in Turner to distinguish People versus Murray, a case where the defendant was told about post-release supervision at the plea, and then at sentence, the only difference was the term of post-release supervision was changed from 2 years to 3 years. So the court says that in that situation, the defendant is already aware of the nature of that sentence, specifically that if he violates the terms of PRS, then his term in prison could be extended. And that's exactly the situation.
So would you require a rule that at the time of plea, the court puts on the record every variation of sentence that could be imposed?
No, I'm asking for the imposition of the rule that already exists, which is that the court must make a clear record of each and every direct consequence of the plea. And a conditional discharge is clearly a direct consequence of the plea. It's an authorized sentence in the penal law. It's not something that can just be merely kind of suggested by announcing only one part of a conditional discharge, which is don't get rearrested. For that matter, then a court can just impose probation by saying don't get rearrested because not
Oh,
getting...
counsel, I'm on the screen. Can I just clarify this part of your argument in response to Judge Troutman's question about what's the rule you're seeking? Is the rule that you've got to say you're subject to a conditional discharge and how long the conditions are being imposed? Or is it just, I've got to run through all the conditions even if I don't tell you the length of time? Or is it enough to just say conditions will be imposed and they're going to last a year? I mean, in this case, what would have been enough? What did the judge have to say?
I think the judge
At the plea.
just had to say conditional discharge with the condition being 20 days of community service. It's not that difficult to ask a judge to merely pronounce the actual name of the sentence at the plea to fulfill the...
So the judge didn't have to say, and it's lasting a year?
Oh, 1 year conditional discharge, yes. We believe that the judge would have to impose...
Yeah,
the
so
term.
that's, okay, so if the judge has said, or had not said not said the words conditional discharge, but said you'll be subject to conditions for a year, and then didn't set out the other conditions, community service has already been explained, so I'm not going to refer to that. Would that have been enough?
I think the better rule is just to use the name of the sentence as it's laid out in the penal law and not to merely suggest what the sentence is, to give the accused person actual clear notice of what the plea bargain that they're entering into is and what a direct consequence of that bargain will be.
I may have misunderstood your argument. I thought your whole point to that was so that a defendant would know what, if any, limitations are placed on their liberty.
Yes, so I'm
Okay,
maybe not following.
Does it, so that, yes, I'm sorry. So doesn't that mean you have to tell them the amount of time their liberty is constrained as well as the nature of the constraints?
Yes, we are asking that the court make a record at the plea of both the name of the sentence and the duration of the sentence.
So
And
wha-
here,
So the
neither,
specific words must be, Mr. Defendant, this court sentences you to a conditional discharge, the duration of which is 1 year, and the condition attached is community service.
that's correct.
And if they don't say, if the court only says a conditional discharge and the service is, the condition is community service, by eliminating 1 year, is that what you are suggesting, that that's not sufficient?
It is our position that the 1 year should be included, but here, there was not any mention of a conditional discharge. The only thing the court said was, if you don't complete 20 days of community
No,
service, you'll go
I'm
to jail.
piggybacking on Judge Rivera's question. What are the specific words that must be said? Both 1 year, conditional discharge, and then the conditions of the conditional discharge?
Yes, I believe it is specified in the criminal procedure law that when a court does impose a sentence of a conditional discharge, it must specify the conditions of that discharge and the
Yeah.
And
length.
so why is this appeal not, sorry, over here, why is it not moot?
It's not moot because there's never been a prejudice requirement in People versus Van Dusen. The court held that for a Cat 2 error, the defendant does not have to show that they would have not taken the plea, that if the plea had been vacated, that they would have chosen to not take the plea. So Mr. Bush suffered serious harm by living under the threat of incarceration for 1 year, by serving an entirely additional sentence when he thought that he was getting a sentence of 20 days community service, and in
Well,
fact, he
that
diligently
injury, I mean,
completed.
if he did suffer some injury, mental anguish or whatever during that year, we can't take that back. We can't remedy that. As I understand it, a year went by, he wasn't rearrested, there was no other adverse consequence.
Judge, we still think that does require reversal, even though he completed the year with no new arrests, but he did have to serve an entirely additional sentence that was not part of his plea agreement.
Well,
And if you
just
take that to its logical conclusion, the
Help me out here
court.
with the consequence of a conditional discharge, if you meet the conditions, is that there's no conviction. Is that right or wrong?
No, it's just a sentence. The conviction still stands.
Okay.
But we do believe that in this case, because Mr. Bush cannot be made whole, as Your Honor is pointing out, by plea vacatur, that dismissal of the case is warranted.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the court. This case, there was nothing wrong with the plea itself. The plea as it stood was completely legal on its face. Defendant was told that if he satisfied the conditions, the 20 days community service, the $250 mandatory surcharge, and the 6-month license suspension, he would in essence be sentenced to an unconditional discharge. Notably, this court has upheld cases where interim probation is issued as part of the sentence before the sentence is actually imposed. So although the unconditional discharge words were not uttered in substance, the defendant was told at the plea proceeding that if he satisfied these requirements, he would get nothing more.
So, counsel, can I just be clear? I'm sorry, I'm on the screen. There were no other conditions? Only the ones you've named? And the minute he satisfied them, he was done? Is that correct?
Well, Your Honor, between the time of the plea and the sentence, he was not to get rearrested. He had to show up to court. But
Right.
after that point, the court never spoke of any additional conditions that Mr. Bush had to satisfy as part of this plea agreement.
So, I'm sorry. So then the form and the 1 year have no applicability here?
Your Honor, there was a mistake here. The court, the defense attorney and the prosecutor surely made a mistake at the sentencing proceeding. The conditional discharge should never have been issued. The defendant should have received the unconditional discharge, but that goes to the validity of the sentence and not the validity of the plea. So the defendant's complaint in this case really concerns the validity of the plea, and the remedy he's seeking is not the remedy he deserves or is entitled to. Tellingly,
All right, but before we get to the remedy, can you explain why this error that you say occurred, that it should have been an unconditional discharge?
well, Your Honor, he was told at the plea proceeding that if he satisfied those requirements, namely completing the 20 days of community service, not getting rearrested and showing up to court, then he would be, he would be sentenced he would receive a 6-month license suspension, and there would be an imposition of a $250 surcharge. Now, at the sentence proceeding, the court imposed a conditional discharge. That aspect of the sentence should not have been uttered, and the defendant should have received the benefit of his bargain, which is namely the unconditional discharge.
So, okay, so you're saying that exactly what he was told at the plea were the only conditions that validly could be imposed, or that because that's what was imposed, that is his sentence?
Well,
Or that's what was mentioned, excuse me, that was the sentence that should have been imposed?
Well, Your Honor, my position, our position is that that's the sentence that should have been imposed. Of course, the court had the authority to increase the sentence at the sentencing proceeding, as is often done in cases where the victim speaks or the court learns something new in between the plea and the sentence. The sentencing court is entitled to increase the sentence. People v. Selikoff and numerous cases thereafter, provide the court the authority to increase the sentence.
Counsel, I'm sorry over here if I missed this, but is this argument you're making here anywhere in your brief that this was an erroneous sentence? I thought your argument was they had an obligation to object to this sentence. And maybe I missed it and you can point me to it, but is there anywhere in your brief where you've said what you just said here in court today, that there was a different agreement and the court made a mistake? Is that in your brief?
No, Your Honor, but we do believe that the defendant had to preserve this argument. But going back to the issue of the validity of the plea, there was no issue with the validity of the plea. The plea itself was legal, and if we look at the face of the proceeding, the record of the plea proceeding, there is nothing wrong with the actual plea itself.
So if what you're saying is true, and I take it at your word, you're saying he should have gotten an unconditional discharge. He can't get that now, so why shouldn't he get the relief that's requested by the defense?
Your Honor, the relief he was entitled to was specific performance. He had relied to his detriment on the community service aspect of his plea. So had the defense attorney objected at sentencing, the court could have and presumably would have. It appears on the record that the court was not wedded to this conditional discharge, as evidenced by the question he asked at the outset of the proceeding. Then the court would have excised that portion of the conditional of the sentence and the 20 days community service. However, dismissal of the plea, of the indictment and vacatur of the plea is not the remedy.
Was the appellate division aware of this position you're taking here? Did you argue before the appellate division that this is a mistake?
We argued that preservation applied, Your Honor.
But the mistake of imposition of a conditional as opposed to an unconditional, you're acknowledging was not argued in the appellate division?
It was not. Had it been argued had it been the defendant's position and had that been argued, we would not have opposed that relief, and we would have consented to the aspect of vacating the conditional discharge. But just going back to the remedy for a second, Your Honor, while the defendant can't be put back to his original position, is akin to cases where a defendant is tried, convicted, and later on raises a claim on appeal, which ultimately is meritorious. The defendant doesn't just the remedy isn't just dismissal of the indictment and vacatur of the plea. He's entitled to a retrial. So while he isn't entirely made whole, that is the best that the criminal procedural law provides for. It's not a perfect solution, but there's not much more that can be done in that respect. So just to reiterate and just to respond to my adversary's argument about People v. Turner and the line of other cases, McAlpin, et cetera.
Counsel, I'm sorry, I just want to clarify something from your view about the actual sentence that is imposed. Is it your view that since, although it's not clear to me when the 1 year runs, maybe you know when the judge intended the 1 year to run from, I assume from the day of sentencing, but you can tell me otherwise. Anyway, that for 1 year he was subject, his understanding was he was subject to all of those conditions, and if he violated any condition, that then he would have, what would have happened?
Well, Your Honor, there would have been an Owley hearing, and it would have been determined whether he had violated any of those conditions, and presumably if he were in fact in violation of any of those conditions, he would be convicted of, a violation of the conditional discharge.
Would he have been able to raise the claim he's raising now in any of these opportunities? Would he, or would he have been able to make the claim that you say, that you now concede that it's an unlawful sentence? I'm just trying to get straight what this procedure would have been, should he have violated during the 1 year, because are you conceding that, given that the 1 year was imposed, again, if he violated any conditions, he's now subject to some kind of hearing, potentially some kind of sanction? Just trying to be clear on what would have happened.
In terms of what the defendant, if I'm understanding correctly, Your Honor, in terms of what the defendant should have done at the time the sentence of conditional discharge was imposed?
No, I'm asking if during the 1 year after sentencing, if during the period during which he is subject to what you now say is an unlawful sentence, but let's just stay with this. And I thought you did mention it in your brief to us, but it may very well be you didn't raise it in the AD. But in any event, if indeed he violated anything, you're saying, yes, he would have gone before the court. He would have been brought in for a violation. And so I was just trying to clarify your perspective, your view as to how this would have played itself out if indeed the conditions he's subject to had been allegedly violated during the period of time he's subject to them.
Your Honor, had he raised the fact that this conditional discharge never should have been issued in the first place, then there would be no violation of the conditional discharge, and whatever, had it been a new crime, then he would face the consequences of that crime alone. If I may just finish with one point, Your Honor.
Yes, please.
Just to distinguish this case from People v. Turner, People v. McAlpin, and People v. Lurie, those cases all dealt with post-release supervision, and in each one of those cases, the plea itself, standing on its own, was invalid. So the defendant could never have received the benefit of his bargain at the time the plea was issued. In this case, however, the plea itself on its own was valid, and the promise could have been imposed at sentencing. Thank you.
Thank you, counsel. Counsel, your rebuttal?
Counsel, would you like to respond to this point that the sentence was erroneous?
The last point?
Yeah, that this is not the sentence that was agreed upon at all. Do you see that anywhere in the briefs before this court?
No, I think it's telling that Respondent is bringing up a completely new argument, oral argument in front of this court that was not raised below, that was not raised in these briefs. I think that's a real reach to say, to make these arguments, because Respondent is aware that this court has already fashioned a rule that, if applied as it should be in this case, dictates the outcome here. And
But do we
versus-
think that it might change the outcome, the fact that I just heard, that this was not the agreed upon sentence?
I'm sorry, which was not the agreed upon sentence?
That this conditional discharge was an error. It should never have been imposed.
That's not how it's not how courts operate. It's not how we should, create confidence in our justice system, is to say, oh, actually, it was a mistake. We agreed on this as the sentence, and now we're giving you this other thing that in fact really undermines confidence in our justice system.
Counsel, I'm on the screen. I'm a little unclear. Perhaps not this exact argument about the lawfulness of the sentence. I thought they did argue in their brief here that an unconditional discharge could have been imposed, and I thought your response was that no, that couldn't be imposed, which goes to the lawfulness of the sentence. Did I misunderstand this briefing?
No, I think that on second consideration, the court could have. Our position is the court could have fashioned a creative remedy to make Mr. Bush whole at that point. The court could have, for instance, imposed a conditional discharge and then immediately terminated it.
But counsel, I think that the issue that I think we're going sideways on here on the bench is, my understanding of the argument, that argument Judge Rivera just said, reiterated, is, look, this is a sentence that could have been imposed, unlike the PSR sentences, this sentence with a conditional discharge, this was legal under the statute. It's not unlawful. What I thought I just heard, though, was that wasn't the agreed-upon sentence in this case, that there should not have been a conditional discharge imposed here, and the argument now appears to be no harm, no foul. We didn't agree to, the defendant never agreed to a conditional discharge, but one got imposed, but, should have objected. I never heard the part about, that I can recall, that there was no agreement to impose conditional discharge. I thought the argument was when the judge says CD, that's what people had agreed to. But
Yes,
it
that's my
seems-
understanding of their argument as well, that, maybe the lawyers had understood that to be the promise, but that was not what was told to Mr. Bush. What was told to him was just 20 days community service, and in fact, he diligently completed those 20 days before he even returned to court. It was 20 days out of a 2.5-month period, which was every single
So
weekend.
basically, at the trial court level, everyone was confused about what the sentence was supposed to be.
I don't think we can know for certain, but what we do know is that Mr. Bush was not told that he would face a one-year...
But it's not until today we're told, well, he should have gotten a CD. The people say he did not receive the benefit of his bargain. Today they say that.
Yeah, it's easy for them to say today, but that's not what happened. He didn't receive the benefit of his bargain.
No, they said he didn't. He was supposed to get an unconditional discharge. He got a conditional discharge, but he shouldn't get the relief that you're requesting, is their argument.
I understand that, but as I've cited earlier, this court has never found that there is a prejudice requirement, and we do believe that living under conditional discharge for an additional year, serving an additional sentence, was a harm that Mr. Bush suffered, and so we do ask this court to reverse.
Thank you, counsel.
Thank you.